Hi folks, my name is Greg McLawsen. I am the Affidavit of Support lawyer. I represent green card holders in federal litigation to enforce the USCIS Form I-864. Oftentimes when somebody decides that they probably have rights to enforce under the Affidavit of Support and they want to go about doing that, they're concerned because they don't actually have a copy of the I-864 contract. So what do you do in that situation? In fact, when folks come to my law firm to enforce the Affidavit of Support, more times than not, they don't actually have the document. But that's actually not a problem, and it's never stopped us from being able to bring an enforcement lawsuit. Let's talk about 3 different approaches you could take if you don't have the Affidavit of Support. Number 1, the Affidavit of Support is required in all family-based immigration cases. So we know it's called as a matter of law, which is to say necessarily. If somebody got their green card through a family member, we know that there was an Affidavit of Support signed. So if nothing else, if we never actually get our hands on that Affidavit of Support contract, we still know with a certainty that the U.S. petitioner, the person who brought the foreign national over, must have signed an Affidavit of Support. Because without that Affidavit of Support, it would have been legally impossible for the U.S. government to grant status to that foreign national. So in very limited circumstances, we will sometimes pull in an expert witness, which is an immigration lawyer who can testify to the law on that issue and say, look, judge, there is no way that this person could have come to the United States without an Affidavit of Support that was signed. Now, we usually don't go about it using an expert witness because the 2 other options that I'll describe next are so much easier. But there have been rare circumstances, usually in a case that's moving very fast, where we've relied on an expert witness to establish the existence of an Affidavit of Support even without actually having the document. Option number 2 is that if you were represented by an attorney, you have a right to acquire all of your files from that attorney. So not all the time, I don't know, maybe 15-20% of the time, folks will be represented by an immigration lawyer either in the visa process or in the green card application process. Now, sometimes the foreign national may not have actually had all of that much interaction with the attorney. A lot of times it's the U.S. citizen sponsor who hired the attorney, is paying for the attorney fees, and had most of the interaction with the attorney. However, if that immigration attorney prepared your I-485 green card application, or if they prepared your visa application, that attorney is your attorney. Even though the U.S. citizen was paying for the legal fees, that doesn't change the fact that this was your legal representative. That means, under the law of every state that I'm familiar with, you have a legal right to your client file. That includes your visa application or green card application, and it includes the Affidavit of Support because that was submitted in connection with your application. Now, I deal with this all the time, and more often than not, when I go to an attorney and demand my client's file, very nicely, they will say, no, that person wasn't my client, I only represented the U.S. citizen. And that is garbage. Immigration attorneys know very well that when you work with a couple in the green card process, you have a joint representation of both parties. And because of that, you owe a joint and equal legal fiduciary duty to each one. Each one is equally your client, and each one has an equal ability to access the client file. So don't take no as an answer. If an immigration attorney prepared your case for you, you're entitled to get a copy of your file. Usually, sooner or later, when I have to grapple with immigration attorneys on this, eventually they will capitulate and ultimately recognize the fact that they need to hand over the client file. Option number 3, so we talked about using an expert witness, getting your file from an attorney if you were represented. Number 3 is a Freedom of Information Act, a FOIA, as we call it in the legal industry. all of your documents as a non-citizen are compiled by USCIS in this big document archive. Obviously, it's digital these days. You can request, and there is no charge associated with this, a complete copy of what is called, this sounds a little bit weird, it's called your alien file. Alien, like thing from another planet. That's the US immigration term that applies to foreign nationals. Sorry, that's just the way it is. So you can file a FOIA request asking, don't ask just for your I-864. Remember, it's free. So ask for your full alien file. And USCIS will send that to you in digital format if you want, or on a CD. It takes about 45 days, plus or minus, sometimes a little bit longer, rarely shorter. You can do this by visiting, if you just Google USCIS FOIA, you'll find that as one of your first two results. The G639 is the form that you can file by mail. And when you fill it out, you'll see that you have to certify who you are. Obviously, you need to demonstrate to USCIS that you are the subject of the records. And it'll say, I promise to pay up to $25 in fees. You don't actually end up paying that. USCIS, I've filed unknown amounts of FOIAs in my professional life. I've never been charged a fee by USCIS. They just don't do it as a matter of practice. So don't be scared. You're not going to be sent a bill for $25. And in 45 days or so, you will have your I-864 along with all of these other documents that were filed in your immigration case. Now, the one kind of downside of a FOIA, I guess I wouldn't call it a downside. I do these in absolutely all of my affidavit of support enforcement cases. But one of the aspects of a FOIA is that under the U.S. Privacy Act, information pertaining to the financial or biographical details of a U.S. citizen are going to be redacted on this. So birthdays, financial information, things like that are going to be blacked out. And USCIS is like wildly variant in terms of how much information they redact. So I will get alien files with nothing redacted. I will get alien files where practically everything is redacted except for my client's information. Usually it's somewhere in the middle. And in almost all cases, when that alien file result comes back, you'll have certainly the affidavit of support and enough details on it to make it very clear that yes, the sponsor did sign it. And if it comes back so heavily redacted that you can't use it, you can either appeal the results of that FOIA request. There's no charge for doing that. Or you will also see on the responsive letter a way that you can just submit an inquiry and ask if part of the information could be unredacted. Those are the three options. Expert witness to say that the affidavit of support was signed, very rarely used, but it's a possibility. Immigration attorney request, if you are represented by counsel, I definitely recommend you do that because it is your right and the information will come back without any redactions. And then number three, because it is cost-free and because it is the best way of getting your entire immigration file a FOIA request. The bottom line for sure is that you should not, under any circumstances, be scared away from thinking about an affidavit enforcement case just because you don't have your affidavit of support. Because again, almost nobody that I talk to still has a copy of their I-864. They either never had it in the first place or they lost it. And it just doesn't matter. I have never had that prevent us from going forward with an enforcement case. If you have any questions, drop them into the comments. I'm happy to answer them there. If you would like an individualized assessment of your rights under the affidavit of support, feel free to reach out. I do consultations all across the United States. Take care.